Thank you so much for having me. I would like to introduce myself. I am Advocate Naman Pareek. I'm currently practicing in Rajasthan High Court, Jaipur bench. I did my graduation from Institute of Law, Nirma University. It's a college in Ahmedabad. And yeah, thank you for having me. I would like to discuss each and everything that you would ask me.
Thank you for your enthusiasm. I'm sure your insights will be very valuable. Since you're coming from a legal background, we would like to know your thoughts on bill writing and what's the current scenario and practice in your experience.
Okay. So first of all, we should discuss about what a will really is. A will is a legal declaration of a person who who decides how he should distribute his property between his family before he dies. So what a will does is it bridges a gap between succession done by law and succession done by a will. So if a person dies intestate, it means if he hasn't drafted in will towards his family, so the state shall have the responsibility to distribute his property. But if a person has written down his will, it is now being governed by it is now being governed by a will act.
Hmm.
So that will act as a law, and that will decide how the property of that particular person shall be distributed in the family. So this is, I think, having a will is shall be considered as an utmost priority by every family, no matter what their financial condition is. But unfortunately, we do not have the social awareness towards this topic, and therefore we are having this discussion. And therefore, we shall try to, give some insights to the people that how important drafting a will before dying intestate is. So, yeah. And the second part of the question, sorry, I forgot to answer. The second part of the question is the things that I have witnessed during my internships and during my practices. When a person dies intestate, so the family involves in a dispute, and the dispute goes on for decades, and there are n number of litigations by every member of that particular family. So this is a serious disadvantage if the law is permitting you, if the law is giving you a choice that you can have a will and you can distribute your property among the family members with your choice. That if you want to give someone some extra property or some extra benefit, then you can definitely jot it down in your will. But unfortunately, due to lack of awareness, I've seen people asking me whether I should write a will or not. But the answer is definitely yes, because if you die intestate, the state has the responsibility to distribute your property.
So, do you think will writing is only needed for people with high net worth, or is it needed for families belonging to middle classes too?
No, 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 definitely not. It shall be a necessity in a family, first of all. Because if you die intestate, if you die without writing a will, then the state will take the responsibility of distributing your property. So it doesn't matter whether you're middle class or whether you're upper middle class or whether you're extremely rich or extremely poor. That hardly matters. Even if you have a single property with one son or two son or three daughters or four daughters, three son, hardly matters. You should definitely write a will because once you die, you do not have a chance, you do not have an opportunity. After you die, you don't have any right or power to do something. So you should write a will while you are in this world, while you live. So it's very important. Hardly matters what is your financial condition. It hardly matters. Even if you have a single property, you should definitely write down a will.
Yes, you're right. So, would you say there's any right age for creating a will?
Okay. So there is no right age. Okay. Any person can create a will, but Section 63 of Indian Succession Act, it states that a person who's a major and who's of a sound mind is shall be creating a will. Okay. So what is a major? Any person who is above 18 has a right to create a will. And any person who has a sound mind, which means he shall be sane. Okay. He shall be sane while drafting a will. So the question arises is, at the time of writing a will, I was sane. And after writing a will, suppose 7 days or 10 days, a medical hospital, any hospital or any family member declares that I'm insane now. So the court will decide that whether at the time of writing that will I was sane or I was insane. Okay. So if the court decides that while writing the will I was sane, then the will is totally legal. The will is totally valid. There's no chance of the will getting void. Okay. And the second is a person shall be major. If someone is below 18, I don't think he acquires any property, neither is legal to, create a will before you turn 18. So these are the two conditions under Section 63 of Indian Succession Act.
Alright. So, could you tell us what kind of troubles families go through in the absence of a will?
Okay, that's a good question. So, suppose if a family member who acquires 7 or 8 properties dies in a sudden accident. So what will happen is if he has two brothers or two two brothers and two sons, either they'll try to distribute that property very amicably. But if someone if someone thinks that he was more close to that particular person who died, he will claim that I was closer to him and I should get more property. Any person can claim that. So in that case, the dispute arises, and one of the family member will definitely file a partition suit. Okay. In partition suit, what happens is every family member, the court will accept the partition suit and will issue notice to every other family member. Okay. And will put stay on all the property that particular person acquires. So in that period, when the case is going on, no family member is allowed to sell or alienate any kind of property that the person acquired who died in that particular accident.
Hmm.
So that stay will continue till the litigation ends, and the litigation will take decades. It's very simple. It will take decades in the trial court, it will take decades in high court, and it will take half a decade in Supreme Court, and might take a decade in Supreme Court as well. So to buy, I don't think a family should consider litigations because drafting a will is a very easy task if you compare it with litigations. So these are the kind of problems that a family suffer if a person dies intestate without writing a will. So definitely there's a high chance that a dispute might arise in future, and all the family members might have to drag to the court, or they'll have to cut their time, office time, every time to go to the court every day or go to the court every week to end that particular litigation so that they can sell their property. So it's a very lengthy process. It's a very hard process. I have seen people getting frustrated during the litigations thing. After filing the litigation, after filing the suit, when decade passes, they decide we should have a settlement. So ultimately you are having a settlement. So why not before? Why not before? Why not when you are alive? One person should settle each and every point, each and every property that he acquires during he stays in this world, while he is alive. His family should not suffer. So it's very important to have a will.
Alright. So, talking of lengthy procedure, generally, what kind of timeline does it take to settle inheritance disputes in the court of law?
Okay, so I've mentioned it before. See, there's no time limit. Unfortunately, there is no time limit. Court, if a partition suit is getting filed in primarily in trial court, primarily in a civil court, so that the judge will, he'll peruse every document, he'll peruse whether you have drafted a will or not, he'll peruse the property documents, he'll ask witnesses some questions. There will be examination in chief, examination in cross. Every family member has to file an affidavit. So it's a very lengthy process. Then there will be interim orders, there will be interim arguments on orders. So it's a very lengthy. There will be n number of applications, and then the final argument stage will come. The judge will give a judgment, decree, and then there's a high chance that one person might file an appeal in high court, and the cycle goes on, the vicious cycle goes on. So it's a very lengthy process. So there's no time limit, unfortunately.
I see. In your experience, what would you say is like the shortest and longest time you have seen a case go on for?
Okay, so I have read files of partition suit that starts in 1988
Oh,
during my internship and during my practice. I've read files, very thick file, and the matter is still going on. The family is not ready for settlement. They have ego clashes. So, it will take around 10, 15 years more to finally we can. So finally, the judge will decide how the law states how the family shall get distributed. So I have witnessed a very lengthy partition suit. So I won't suggest anyone to file a file a partition suit. Instead, you can have a simple will. It's a very easy process comparatively.
I see. Yes. So thank you so much for your time. That is it from our side. Do you have any final words?
My final words would be to every person who is watching this video to just have a will, avoid litigations. That's it. Because uh, it will take time. The partition, so if you file a partition suit, it will take time. Instead, you can have a will. And if you have this question, I'm just 40, whether I should draft a will or not. So let me just tell you something that you can amend your will at any point of your life because a will become operative once you leave this world, once you die. So till the time you are in this world, till the time you don't perish, you have every right to amend your will. So even if you're 40 and have this perpetual question whether I should draft a will or not, you should definitely draft. And when you turn 70, you can just amend it. It's very simple. So that will be my conclusionary remark to everyone who's watching this video.
Yes. All right. Thank you so much for being a part of this discussion. Your insights were very helpful.